Again, looking at pitfalls and what you don't know, or potholes, that's the purpose of why we do this session. And this is for background education only, because legal stuff is very fact specific, and the goal here is to have you appreciate that there might be an issue that you need to address, or to recognize that there may be a problem. And we'll talk a little bit about, how do you deal with lawyers on that type of thing. So I'm going to give you more stuff than you could possibly digest, and we may not even have time for all of it. So what I've done is figuring that I've organized things by the life cycle of a company, starting in the columns here from the earliest ideas section all the way to, exits at the other end, and have looked in the horizontal on the rows at, various areas: intellectual property, legal entity, people issues, and financing. And I'm just going to plow through this. And since we're starting at the earliest stage, it's probably most relevant to where you are now and what you're looking at. And we'll see as far as we can go. And the deck is already at the website for you to look at. So with that in mind, let's look at the idea stage. So from an intellectual property viewpoint, the first thing is who owns the idea, or what is the idea, and who owns it, and what are the options on that. And then how we might protect it. This is falling just from some of the questions we just heard. So one thing to recognize, if you haven't seen the statistic, is if you look at the percentage of value of companies, and these are the big companies, the Fortune, the S&P 500, the percentage of that market value of the companies in 2015 had got up to about 84% were intangibles. Intangibles are, once you take out all of the tangibles, that's plant, equipment, and other things, intangibles are what's left, and that can include everything from intellectual capital, intellectual property, people, etc. But a lot more of it is intellectual property. So let's look at types of IP protection that you could look at for an idea or what you're working on. They range from no protection at all, trade secret, trademark, copyright, patent, and combinations of protection. And if you look at trade secret, this is something, if you keep something secret, obviously it can prevent others from doing it because they don't know how to do it. Trademark and copyright are things that enhance value, but they don't really block others. They enhance value. Patents cut both ways, because as we'll see as we go through this, with a patent you have a right to prevent others from practicing the invention you have, but in order to get a patent you have to disclose how you do it. So you're also enabling people when your patent protection goes away. If we look at it in terms of duration, how long is this protection? Patents are actually the shortest. It's 20 years from the date of filing in the US, and trade secrets could be indefinite. If you look at the cost, it goes the other way. That is, the patents are the most expensive. And this protection of intellectual property is really a country-by-country thing. So today I'm going to focus on the US, and I'll throw in some foreign things when appropriate. So before you start to think about, well, what am I going to do with the ideas that I have, is to think about what are your needs. Is there a core technology that needs to be protected? Do you have a product? Is there a risk that somebody could easily reverse engineer it? Is the lifespan of the product short? If your business model is to manufacture and sell, that's one set of things. If you're going to license and partner, then you're going to really have to develop a portfolio of intellectual property. And then you have to look at, are there non-intellectual property bars to market entry like regulatory, FDA or other kind of things? And then what about exit strategy? these are the things that should go into your mind. So let's go through the categories here. Trade secret is a secret, something gives you advantage in the marketplace. The classic one is the formula for Coke. Coca-Cola is still a trade secret. Apparently it's protected and nobody knows it. Although when you think about Coca-Cola and you think of the alternatives of Pepsi, now we're into things like trademark and the like. But for trade secrets, this is a state-by-state thing. Protection granted varies from state to state. And you can maintain a trade secret as long as you keep it secret. And that's why you end up with non-disclosure agreements. Now, in dealing with investors, you don't really want to put the trade secrets right out there at the beginning. And investors typically will not sign non-disclosure agreements because they're getting hit with so many different ideas that may be similar. They don't want to be at risk for having, quote, stolen your idea. So that comes back to what you're trying to tell them. You're trying to show that you're creating value with whatever it is you have as a trade secret. And that's what you want to push, the value for who. You don't have to actually talk about the specific trade secrets. Then we move to trademark or service mark. These are things that develop a name that people connect with you. A trademark would be for goods, a service mark for services. And what they are things that customers, when they hear, people hear, think of you. And it can be words, logo, even color. The red soles on these spike heels, go immediately, you know who they are. Or sound, and I'll give you some examples. There are marks under which you sell goods or services. So-called house marks are really about who's doing the selling. So Lenovo, Virtual Ink, our case study, or MGM with a sound. The lion's roar is actually a trademark related to that. And then underneath that there would be product marks. So ThinkPad is a product that Lenovo puts out there. It originally was owned by IBM. Memo is Virtual Ink. And if you think of Rocky, the movie, that's an MGM property. And so you can trademark at sort of the company level and at the product level. Now, trademarks arise from use in commerce. That is, once you put something out there with the name on it, then you have established the beginnings of a trademark. It used to be that you had to register. You had to actually sell something in commerce before you could register it at the federal level, which made it sort of a cumbersome thing because you'd have to develop the product, the mark, the marketing materials. Then the rules got changed, so you could also have a filing called an intent to use. So saying, I intend to use this mark on these goods or services. And once you file that, you have a period of time to actually use it. And essentially, once you do get a trademark, it can last forever. There's some registration and filing issues, but it can last forever. When you are claiming a trademark, before you've registered it federally, you'd want to use a TM next to the word or the phrase or whatever for goods, and an SM for services. And when you do actually register it with the Patent and Trademark Office, then you can use the little R in a circle. And you register goods for particular classes of goods or services. And so we won't get into the detail of all of that. Now, there is the issue of a senior unregistered user. So if somebody uses a mark in an area, a classic case was the McDonald's restaurant in upstate New York. Apparently there were a couple of McDonald's restaurants that were not the Golden Arches that predated the formation of the McDonald Golden Arch Company. McDonald's, when they register it federally, they get presumptive rights across the whole country for the particular goods. But the upstate New York restaurant has senior rights in that particular area and can continue to use that. This is probably more important in the pre-internet age. Now when you're selling from everywhere, anywhere, it's hard to say where you actually did sell. What you want to do is pick a fanciful mark. If you think about Apple, who would have thought of Apple as a computer? iPod, Memo, those are fanciful marks, as opposed to descriptive marks that are storage technology or analog devices. In fact, if it's merely descriptive, you won't be able to get a trademark. Before you spend a lot of time and money or effort at establishing a brand, check the availability at the U.S. Patent and Trademark Office. They have a trademark database. You can type in words and find out whether there are any registered marks out there. So if we move on to copyright, copyright is the right to either make or prevent others from making copies. And this arises, we're talking about original works of authorship. From the creation of a work, that's when a copyright arises. A copyright protects the expression in the work, not the function. So, for example, you could copyright music, and that's an expression of something, versus software, which can be copyrighted, but it's not quite as good because software is there not as an expression, but more as a function. The reason for that is if Shakespeare could do Romeo and Juliet and copyright the concept of Romeo and Juliet, then there never would have been a West Side Story, because that would have been a violation of that copyright. So it's a protection of a particular expression of an idea. Federal registration is a plus because with that you can actually bring suit and get certain benefits for people who are violating your copyright. The duration is long. It can be 70 plus years. The cost to register is low. And the suggested notice you want to put on the thing that you're copywriting is the copyright symbol, the C in the circle, year, and the author, and then all rights reserved. An example of that is at the footer of the slide. For your venture, what you need to make sure is that you actually have the rights you think you have. So the thing that is created is owned by the author, unless the author is an employee and it's in the scope of employment, or the work is created as a so-called work for hire under an agreement that says that the person who commissions the work is going to be the owner. So for example, if you're starting off in a venture and you're using independent contractors or programmers, and you don't have an agreement who's going to own it, you won't own it. It'll be the programmer. If you're a small company going to do some work for a large company, the first thing you're going to get is a consultant agreement. You're an independent contractor, consultant agreement that says they're going to own everything that you do. And for programming and other things, then you'll have to negotiate that to say, well, you can own the specific thing that I deliver, but not all the tools and other things that I, bring to the job. You do want to check for open source issues. If you are incorporating open source code in your product, you want to make sure that you're complying with the general license on that, and that you don't embed it in there and have a problem when you then try to raise money or sell the company. And then we move to probably the strongest protections, which are patents. These are limited time monopolies. We don't like monopolies in the US. We have antitrust laws, but the idea of patents arises right in the Constitution. And it's basically a trade-off for society that says, we will give you, the inventor, a limited time ability to prevent others from practicing your invention in exchange for you telling everybody how you do it. And so we'll give you 20 years to use and monetize your invention. And the knowledge that you put out there then can be used by others, either when your patent expires or encourages other invention. So a patent is a federally granted right to any system or method that is new, non-obvious, and useful. You actually have to apply for it, and it has to be granted by the patent office, again, on a country-by-country basis. You should think about it like real estate. The fundamental right when you have a piece of property is to prevent other people from trespassing, from walking on your land. It doesn't necessarily give you the right to, in the case of patents, it's the preventing others from making, using, selling, or distributing the patented invention. Ownership, however, doesn't mean that you actually have the right to use it. Now, that seems a little counterintuitive. After all, it's your invention. Well, it's really, think of real estate again. If your piece of property that you own is landlocked by somebody else, you may not be able to access your property because you'd have to walk across that person's land. I'll show you an example of that in a moment. The claims of the patent are what define it. It's like the fence around the property, and that's the key part of your patent. And the duration in the US is 20 years from the date of filing. Here's an example of what I mean about the right to exclude. Let's say you patent a vessel to hold a liquid. And I look at that and I say, well, gee, that's a great idea, but it would be a lot better if it had a handle. So I get a patent on a handle. There can be no handle on the cup without a cross license between us. That is, you can keep me from putting my handle on your cup, and I can keep you from putting a cup on my handle. So if you think of it that way, it makes a lot more sense. So what are the requirements to obtain a patent? Well, first of all, something has to be novel or new, and you're required to disclose to the patent office any so-called prior art that's relevant, that shows that what you have is new. That is, it could be other patents or publications or anything else. And we'll come back to how we can use that to figure out what's out there. It has to be useful. That's not usually an issue. And it has to be patentable subject matter, which is technically any process, machine, manufacture, or composition of matter, or any new and useful improvement thereof. So it took a long while for people to get to the point of understanding that software could be patented. Now, the important thing as you plan your venture is that the thing that you're trying to get a patent on can't have been previously offered or sold or publicly disclosed. And by that I mean an enabling disclosure. So if I say I have a great idea for anti-gravity boots, I haven't really disclosed how I do it. So I have not made an enabling disclosure. If I had made an enabling disclosure, I'd have 1 year in the US, only 1 year in which to file a patent application. And if I didn't do it within a year, I would never be able to get a patent on it. It's even worse internationally. Most other countries, in fact, I'm not aware of any other country where if you disclose before you file, you'll be able to get a patent. So the US has a very unique 1 year window. So the important thing is if you only care about your invention in the US, you have 1 year to do something about it. If you plan to go outside the US, you better file before you disclose anything. Now, what the invention or your idea can't be obvious to one of ordinary skill in the art. And so it's not just a simple addition to what's out there. Often prior art can be used to show that it's not obvious because prior art may teach against what you're doing. People say, oh, you can't make a molecule, a drug with a molecule that small, and you've done it. Also, commercial success can show non-obvious. That is, if everything was so obvious before, how come nobody else had been selling it like you did? And an important thing, because of a change in the patent law in the US in the last 10 years or so, is it's the first inventor to file that gets the patent. So if both of us independently invent something and you get there before I do filing it, then you win and I lose. So it gives you the freedom to make, license, and sell your product. And the question is, do you actually own the technology? So patents, like copyrights, are owned by the inventor or the author, unless it's assigned to a company. And typically, as a technical employee going to an established company, you'd have to sign an agreement saying that you'll assign any inventions that you make in the course of work. You may license from a university. That's another way you could, quote, own the technology, and we'll touch a little bit on MIT's policies on that. And then the other thing is, did you allow your invention to go in the public domain? In other words, did you make a disclosure before you filed? Did you go and offer to sell it before you filed? In which case you wouldn't end up owning it. Now, patents, as you'll see, can be expensive. We'll talk a little bit about disclosing to prevent others from patenting in a couple of slides here. Now, before you launch, you want to figure out, are you free to operate with your idea, or has somebody else already jumped ahead of you and has the rights to what you're doing? Because if you don't do that, investors may do that, and certainly you don't want to spend a lot of time pursuing something if, in fact, you're really going to get blocked as you launch the venture. It can be fatal if you launch without that. You may not, if you end up with a lawsuit. I'm thinking about the pipeline people you just saw, not the people on the call, but there are a couple of people at the pipeline thing that had very good ideas and even had some patents that have been involved in some pretty hefty patent suits. And nobody really wants to buy that. So understanding the space is important. So how do you find prior art? Well, actually, a company that I co-founded is something you can use for that, and we make it available to MIT people. It's called seetheforest.com. So if you write that down and afterwards want to use it, just send me an email from your MIT email address and register at See the Forest. Send me an email, and we'll upgrade you to premium status. But here's an example. Virtual Ink had a patent. That's our case study. What you're looking at here is a patent map. That is, the x-axis is time. The boxes are patents aligned in time. And in this case, the yellow one here was the first Virtual Ink patent when it issued. It cited prior art, these other patents, as part of the process for getting that patent. And so by mapping that out, you can begin to see who's in the space. So the lines between, I look up here in the upper right, the lines between the boxes show that this patent cited this patent as prior art. The blue tails show when they were filed, and information about the patents are inside. And when you map this out, you can find out who's actually on this particular map. This was obviously when the patent issued. And here's what it looked like several years later. You can see to the right in the bottom other patents citing the Virtual Ink patent. So by tracking this, first understanding the space at a high level, being able to even skim over and look at these can save a lot of time and actually help you think about how your invention should evolve. This was the Virtual Ink total patent portfolio when it at one point in time. These are called landscape maps, where each of these were the Virtual Ink patents, and these were the forward citations. These are the patents citing the Virtual Ink patents at a point in time, and here are the companies. And that was in 2012 on the left. By 2019, you can see how many more patents it issued. So obviously a fast-growing space. And keeping track of that as part of your ongoing development and even your business strategy can be important. So let me just take that back. If you'd like to try this, again, go to seetheforest.com, register for a free account, and then we'll upgrade you, and we can do a tutorial on how to do it. Okay, so how do you go about obtaining once you decide you really want to get a patent? Well, there are four main parts of it. One is determining what to patent, determining when to file, preparing the applications, and quote, prosecuting. Prosecuting sounds like a crime, but it's really the process of convincing the patent office that you should have a patent. So at the base level, the important thing is to figure out what to patent. Don't necessarily say, I want to get, can I get a patent on something? You want to ask, well, what should I get a patent on? What is of commercial value? And how would competitors use my technology if I, disclosed it? And you want to compare what you're patenting against prior art. Determining when to file before you lose U.S. or foreign rights become important. I was part of a State Department program involved in entrepreneurship in Muslim countries as part of Obama's Cairo initiative. We were in Istanbul, and I was mentoring a team there from Egypt, and they developed this fantastic wireless compression technology, and they were quite excited about it. And I said, had they published any papers? Oh, yes, they were quite happy because they just published a paper in some prestigious, journal. And I said to them, ooh, and have you filed a patent application? And they said no. And I said, well, the only place you might be able to get a patent might be just the US because you've disclosed your invention. You might have disclosed the invention before you filed. And it was one of these terrible moments where all the effort that they had put into this, you could just see their face, sink. So that's one of the red flag things. Don't disclose before you file if it's something important that you want to get a filing on. And again, a race to the patent office if there are multiple inventors. Separate inventors, we'll come back to that. So how do you, is there a simple way, since patents are expensive, and I'll give you some numbers, and you're a startup, how in the world, you're going to get the money to go and file and prosecute a patent application if it's so important that you do that before you disclose anything? Well, there is this thing called a provisional patent application, and this has been around probably for 15, 20 years now. And what it is it's an application you file with the patent office. It doesn't even have to have any claims in it. It just describes the invention. It's not made public at all. It's part of the file when you actually decide to go and get a full patent. But what it does is establish, both in the US and internationally, a filing date priority. It says on this date, this invention, a patent application was filed. Now, it protects the invention for 1 year, basically. If you don't file what's called a full patent application or a utility application within a year, then you don't get that benefit of that filing date. But you get a year, and that allows you to go out and test the market and to see if people really like the product or whatever, and maybe raise money. It's fast and cheap to do. Nothing happens at the patent office, but if you fail to disclose something in the description of the invention, you won't get the priority date when you go to file the utility. Now, at IP Vision, which was the patent mapping thing I showed you, that's a SaaS platform type thing. And we were doing releases every 6 to 8 weeks. And as part of our normal release cycle, we would sit down and say, well, what feature are we putting out there now that we think we might want to get a patent on? What did we think about but didn't put into it? And we go through a systematic thing, and we would file provisional patent applications every 6 to 8 weeks on what we had, and that allowed us to maintain our priority date and watch how the product developed. And then, of course, 1 year later, we had to decide whether to convert it into a full patent application. So that can be a very viable process for a startup, especially when you show that you've got some smarts about how to do this. Investors will be, will say, okay, they know what they're doing here. So
hey, Joe,
yeah.
We have a few questions in the chat.
Sure.
If you'd like to take them now or later, it's up to you.
Sure. Let me see if we can do that.
Absolutely.
Let's see.
We've got Giovanna first, I believe. Or actually, we have Amy. She has a few questions, and then Giovanna.
Is there a form to ensure you're right when they are not employees? Yeah, you would have your own form of might be if it's truly an outside person, a consultant services agreement that you'd have them sign. The trickier thing is with us before you've started an entity, which we'll talk about a little bit later in the presentation. The people that are working with you on the project, if you haven't agreed who's going to end up owning it, that could be the issue. But it would normally be either a consultant service agreement or something else that would cover that. Let's see, how do you determine what's considered public? It's whether it's an enabling disclosure. In other words, if you can tell from what I say how to do what I'm saying, that could very well be an enabling disclosure. So again, talk about the benefits. We've developed something that's faster, cheaper, smaller, whatever it is. You don't have to explain how you did it, and it's useful for the following things. Those are the kind of things. Don't say, we've decided, we've figured out this, and here's how it actually works. That would be an enabling disclosure. And let's see, if you're an MIT student, part of a team, develop something novel, presented as part of that class, is it public disclosure? Again, I take this at two levels. One is, was it enabling? Did it describe? Could someone have listened to you and figured out how to do it? There is some, don't quote me on this, but there's some learning out there that says in an academic setting, a closed academic setting, it's not a public disclosure, but I would not rely on that. It's better to check beforehand. What else do we have?
We have one from Giovanna. Feel free to unmute yourself. I'll just read it out. Is it possible to sell a product without a patent? Will you get any credit for doing so? Giovanna, thank you for asking the question.
Well, you don't need a patent. You don't need a patent to sell a product. But if you sell a product and then try to go and get a patent on it, in the U.S. you would have that 1 year window before you could file.
We've got another one from John. He's raised his hand. I think he's going to unmute himself.
Okay.
Hi. I have a question about technology development. So say I've developed a process with the university, and but then we leave the university and start developing technology on our own and realize that we have a completely a process which is much better in every way, and it's different than the initial process. Is that a separate patent, and do we need to include the university on that? And what can we use our patent and not theirs? How do we navigate this space where we've grown so much farther past where we were at the university?
Right. Well, typically the way the university does something, they'll and I'll have something here about the technology licensing office in a moment. Typically patents are expensive. Typically a university would file on a core invention, and then the person who licenses it would advance it in a commercial fashion, and would in most cases cite the core patent from the university as prior art. The university, unless you have an agreement to the contrary, which I don't think I've ever seen, you own what you invent. And you don't even have to be using what you licensed. I mean, you may start off with something and you, in the course of developing the product, you might say, gosh, there's a better way to do it, and it's not anything related to the claims on the university patent. A couple things there. You probably wouldn't know any royalties because you're not practicing that invention. And but you may still have that license to prevent other people from using the whatever the university patent said. Does that make sense?
Yeah. So basically, like generation one, we need to license it so we block anybody else from using that less efficient method, but our more efficient method, we get the royalties on. Oh, that's amazing. Thank you so much.
Right. But in the chemical area, a patent on a composition of material or of matter is sort of fundamental, and how you go about making that. You may need that license to that composition of matter in order to actually make the product that you're using. So it depends on the nature of what it is. Their composition of matter patents were very, a lot stronger than methods of making or methods of using things. So again, this is stuff. Again, red flags. You're getting into something. You may go and want to talk to a patent lawyer to understand it, but I'm trying to give you an overview so you know sort of what the questions, are like. So,
yeah.
Are we good on other questions? Can I move on here, or does prior provisionals apply? No, it's not. Your provisional patents are not prior art against yourself. There's the same inventorship. Okay. And there seems to be a backlog at the Patent Office for trademark processing. You should put the TM on whatever you're trademarking right from the beginning, and that alerts people that you're claiming what's called a common law trademark. And it's when it's registered when it's formally registered at the Patent Office, then you use the R in the circle. So you're protecting it by putting the TM there right from the beginning. Okay, I'm going to keep moving if that makes sense. Okay.
Absolutely. Thank you, Joe.
Okay, I'll just skip this one. Here's some costs. These are typical utility patents. Those are not I said that the provisionals were cheap. You don't even really need a patent lawyer to do that. I've seen people who are about to give a paper at a conference slap a cover page on it and send it off to the patent office for the $100 or whatever. It does not have to have claims. Certainly, I think most patent lawyers would say, well, you're better to actually do a full utility application, because then we can be very specific, et cetera, et cetera. All true, but it's a question of cost. If you don't have $5,000 to $15,000 preparing an application, you're much better off to pay $100 to get the provisional filed, and then hope a year later that you think you still have something of value and you have some money, convinced other people, then you can pay them to do the full application. That's the filing fees, the preparing the application. Prosecution, meaning dealing with the patent office, God, it can be anywhere $5,000 to, as it goes out of control. 15. You can't control how many interactions you're going to have with an examiner or your lawyer is going to do. The other thing, this sounds funny, but in one of the companies that I was a co-founder of, I got a bill from the patent lawyers for $35,000 for the application, and I said, "Why $35,000?" Well, it turned out my technical co-founder was spending a lot of time talking to the patent lawyers. Tweak it this way, tweak it that way, and they were just billing by the hour, and so I had to put my foot down and say to the patent lawyers, You don't take any calls unless it comes through me. And then had to have a discussion with my co-founder that, we can't afford this. This is not how we're going to do it. So even though we weren't a big company, we just weren't communicating well. Foreign applications, again, to get a patent is country by country. Foreign applications get expensive. The PCT is the Patent Cooperation Treaty, allows you to file in one country and say, I hope to file in other countries. And that filing fee is more than just the US filing fee. You can file a PCT in the US Here are some of the other numbers for some of the other countries. There was a Government Accounting Office survey in the early 2000s that said for small companies it was $300,000 to $500,000 to file and maintain a single patent in 10 countries over the life of a patent. So it is expensive, or can be. So the the trick here is to go ahead and file in the. I'll give you a real example. We another company that I co-founded. We went and did an aggressive set of filings in the U.S., and then we started to engage with a strategic partner. And you have, I think, 24 to 30 months before you have to file internationally. We did actually file in China. And in the course of our negotiation over the deal we were doing with them, the fact that we'd done this stuff 2 years before, by the time it had started to work through the patent office and everything, it was like a week before we ended up signing the agreement that we got notified that the patent issued in the United States and China. And that just changed the whole negotiation from well, what happens if you don't get a patent and this and that, and they wanted to close really quickly. And as part of that deal, they picked up all of the ongoing filing fees and costs on the US and around the world. So the trick is, move quickly, patent, develop your business and what you're doing, and, be ready for an acquirer would love to, if you've shown all the other things, to know that there's a portfolio of patents that they can build on to protect their investment in taking your product to market or buying your company. So if you want to avoid being what I call picket fenced, a picket fence is a group of patents that surround a patent with the purpose of blocking the commercial implementation. So to go back to my cup thing, if I had the vessel to hold a liquid, you could come along and patent the cap, maybe the sleeve, maybe the handle, maybe a styrofoam insulating thing, with the net effect that I really could not get to market, and in effect steal the value of my core invention. A strategy for startups, and only to be done in connection with talking with a skilled patent lawyer, is if you think you have a core invention that's really strong and you don't have the funds to do all these add-ons, a strategy is to disclose them, is to say, I've got this vessel to hold a liquid, and and in the course of getting the patent, you describe that you can do lots of things with it. You could put a cap, a handle, a sleeve, styrofoam, whatever, and do enough broad disclosures, but not claim it because you don't have the money to do it. And what that means is nobody else could patent on those and block you because it was already out there. It was prior art. An example of a picket fence is this map. You've probably seen the Ring doorbell cameras. The Ring patent is here, and Skybell, these are all Skybell patents, picket fencing around the Ring patent. And in fact, if you look at the history of Skybell and Ring, there was some patent suits that got resolved in favor of Skybell. But that's an example of a picket fence when you see something like that. What other kinds of strategies might be out there? Well, Tesla got a lot of credit for putting 200 or more of their patents sort of in the public domain. And everyone said, oh, isn't Tesla wonderful? They're not going to initiate lawsuits and all of that. Well, that's actually might be a very good patent strategy because, in order for Teslas or electric vehicles to be out there and adopted, there are a lot of other infrastructure things that need to happen, charging stations, all sorts of things. So if you think of Henry Ford, who invented the Model T automobile, he didn't have to patent drilling for oil, extracting oil, making gasoline, building roads and all of that other stuff. So I think the Tesla example is by making those patents available to others in areas where other people would make money developing the infrastructures that would enable Tesla to sell more cars is a shrewd business decision. And for nonprofits, you may have the same concept. Well, if I'm a nonprofit, I'm not trying to make money on the invention that I have. On the other hand, if you do patent that invention, you can actually control who could use it. And that may be part of your strategy for how you have maximum impact. So it could be valuable for you too. So here's a practical checklist on the IP front, keeping an eye on the time. So if you have employees, you probably want an invention disclosure and assignment agreement. That's an agreement that says, if you come to work for me, for the company, you have to disclose any inventions you come up with while you're working here, and you agree to assign those inventions to the company. If you're using consultants, you want a consulting agreement that specifies that it's a work for hire and that it will be owned by you or the company. You'll want to use non-disclosure agreements with third parties where appropriate. And not as, again, be careful what you disclose. And you want to sort of like a little bit of, you want to put a little bait out there, getting people interested enough that they really want to learn more about what you're doing to the point that they'll actually sign a non-disclosure agreement. You want to avoid infringement. You want to make sure you're not infringing someone else's patent. You want to understand the patent landscape. And then you want to make sure you preserve your patent rights. Think about provisional patent applications. Make sure you're filing in a timely fashion. And, avoid being picket fenced. Consider disclosing inventions if in consultation, of course, with, a knowledgeable patent lawyer. So that's sort of a practical checklist for startups. I think I'm going to, I'll just move on here. In dealing with lawyers in general, you have to remember you're purchasing expertise by the hour, typically. And so both in IP and other things you do with lawyers, you want to understand your business goals, plan ahead, keep the attorney informed. In other words, don't wait until the last moment. That gets expensive. If you take your lab notebook and toss it on the lawyer's desk and ask them to put it together, it's going to be more expensive than if you write up a clear description of the invention and its benefits and hand that to the lawyer and have the lawyer spend the time working on the claims, which are going to be the really important things. So if you've never done this, go read some patents, see how they work, and think about writing them up in a way and hand the lawyer a more complete package of things. And then I've got 10 commandments of how to work effectively with lawyers is part of the materials for nuts and bolts. But typically, you can really leverage the expertise. You don't want to be paying by the hour for stuff that could be done by other people. So let me switch to, okay, I do see, what if you have unpaid interns? Well, you have a whole bunch of other issues if you're doing unpaid interns, but we can talk about that later. Let me switch over to university licensing because if you're at MIT, you may be doing things that will involve the Technology Licensing Office. So a little bit of background. Prior to 1980, inventions that were funded by the U.S. or research funded by the U.S. government. The U.S. government owned the patents, and they tended to license those non-exclusively, and very few were commercialized. And then it became clear that it doesn't make sense to centralize all of this. We ought to permit universities to retain ownership of the intellectual property that's being developed at the university. And so Bayh-Dole gave universities the right ownership rights, permitted universities to license exclusively because exclusive licenses in many cases are the things you need in order to attract investment. And the result was dramatically accelerating commercialization. So MIT has a policy on ownership of intellectual property. So in general, MIT owns the patent or copyright if significant use was made of MIT facilities or MIT administered funds were used. Significant use of facilities would be something like the nuclear reactor. It wouldn't be the Athena network. MIT never assigns ownership of patents to a licensee or a research sponsor. It guarantees sponsors first rights to inventions made using their funds. MIT can waive invention to an inventor if there are no sponsorship rights involved, no significant use of MIT facilities, and under these terms. Separate from things that are actually formally research things, recognition that there's a lot of smart people running around the place and they have a lot of ideas. The Technology Licensing Office, the TLO, which is given it's the organization in MIT that administers all the intellectual property. You can go to the TLO and ask to assign your personally owned invention. And why would you do that? Because MIT would handle it in the same manner. That is, they would take on and prosecute the patent, and if it gets commercialized, would share royalty sharing arrangements. Typically, this happens more with faculty members than students. Now, if you're a startup, how can you afford to license something? You have sort of a chicken and egg thing, right? I don't have any money to pay for the license, and I can't raise money unless I have the license. So how do we expand that? Well, there's an opportunity to obtain an option to obtain a license. So if you can get a license, an option from the Technology Licensing Office, can be modest, etc. That allows you now to go, when you're talking to financing sources, we've got a license, an exclusive license, an option to get an exclusive license on this technology that's part of what we're planning to do. And if you put the money in the company, we'll execute the license and everything will be off to the races. And it allows you time to evaluate the technology and markets. Here are typical license finance terms. The components of licenses include the issue fee, to get the license, license maintenance fees every year or so, the requirement of diligence, and let me just show you a typical. If there's no equity involved, issue fee for a license could be $50K to $150K, and the reason for that is, well, that's what it tends to be. Maintenance fees can be something approaching 50% of the running royalties once you are paying royalties, which is, of course, only when you're actually selling something. Diligence, meaning you can't just get the license and leave it on the shelf. You have to actually be working towards bringing a product or service to market. The royalty is a percentage of your sales, is anywhere from 3 to 5% typically. Patent cost, you have to reimburse and pick up the patent costs for the license, for the patents that are licensed. And you're not required to sponsor any research. Now, MIT recognized that it used to be only big companies could afford these kind of things. But on the other hand, wasn't it the smaller companies that actually were more innovative in getting product to market? So how could we span that? And what they did is they have structured deals with equity where MIT gets, and this is typical at other universities too, might get equity or ownership of part of your company as a part of the license. And then, that allowed them to be able to enable smaller companies, startups. Typical equity terms typically is a single-digit percentage of equity, which is maintained through the first $5 to $10 million raised. That is, we get 5% of the company, and it will be 5% once you've raised your first 10 million. And after that, we'll get diluted with everyone else. And we'll talk about dilution, and hopefully we'll reach that tonight. And the university may get a right to participate in future equity rounds, although that's not very typical. These are some royalties ranges for university patents based on the area. These are a little bit dated. I haven't had a chance to poll to see if they're still there, but I wouldn't expect them to be massively different. Again, these are in the slides, so I won't go into them specifically here. And that sort of completes the intellectual property part of the idea, who owns it, how to protect it, how to deal with it, how to come up with a strategy that will get you maybe into the first round of financing. There's a whole nother set of things is ongoing about how do you want to have a patent strategy to enhance the value of your company. That's a whole nother longer discussion, but hopefully these are enough things to keep you thinking about the potholes and things you need to be considering. The next area is the legal entity. How are we going to organize? Do we need to organize anything? And a couple of the issues around that. So at the base, if you do nothing, and there are two or more of you involved, and you do nothing, you probably are going to be deemed to have a general partnership. That's defined as in the Uniform Partnership Act. These are state-by-state things, as two or more persons engaging in business for profit. And so you don't need a written agreement. And what happens is you get joint and several unlimited personal liability. Joint meaning you're jointly liable. Several means each of you is individually liable. And if you don't do anything more, the actual ownership is deemed to be based on the actual dollars invested. And you can picture that no outside investor wants this. If I've got a substantial net worth and I'm teaming up with you in a partnership and you have nothing in terms of assets and there's a problem, then guess who's going to be sitting there as a target? The outside investor. So in most cases, virtually in every case, you do have to form some sort of entity or organization that provides liability protection for the owners of the organization. I can do a whole hour on the pluses and minuses of various types of entities, but typically for the kind of companies that most of you will be involved with, it's going to be a corporation, and often a Delaware corporation, especially if a lot of financing is needed. And Delaware, because it's got a more refined or more history of a corporation law, and it has a separate court that only deals with corporate type things. For those of you who are thinking of nonprofit or social type things, there are other emerging types of corporations called benefit corporations or B corporations. Again, that's a whole set of discussions. It's an emerging area. It's very interesting. And at some point I can do a follow-up with you on that. But the default, I would say, for purposes of this short presentation, is a Delaware corporation. Now, the question is when to incorporate. And the reasons to do it sooner rather than later is to, again, avoid personal liability. You're always liable for your individual acts. This is, can you be liable for the acts of others? And you may want to minimize some 83B taxes, which I'm going to talk about here. If you do get a corporate form, you do have to maintain it. You have to follow the formalities. And I won't tell you the Diva example. That's an interesting story, but just in the interest of time. If you are a corporate form, you may want to think about making an election, an S election. So under federal tax law, a corporation is a separate person. And it could be taxed And if you do nothing, you're taxed under subchapter C of the tax code, which means that if the corporation makes a profit, it has to pay taxes on that. And then when it distributes money to you, you have to pay taxes on it. So there are two levels of tax. If you qualify to be taxed under subchapter S, then there's only one layer of tax. And the qualifications are generally that there are less than 100 shareholders, there's one class of stock, and they're all human beings, and US resident or citizens, not entities like corporations or venture capital. So here's an example of why would we care about this? Because most startups have losses. So, they're not going to be taxed. So why would I want a subchapter S? Well, it's because when you go to exit the company, especially the kind of companies you're looking at, then maybe an asset purchase. And in that case, if you're a C corporation in the example here, you'd end up with an effective tax rate to the owners of 50% because there'd be a tax at the corporate level and then an individual tax. Whereas if you're an S corporation, you'd have an effective rate of 37%. So you save 13%. The DIVA example that I said, DIVA was digital video applications. It was the first spin out of the Media Lab. And they were doing desktop public video editing on the desktop using a Mac computer at a time when the systems elsewhere were $500,000 to $1 million things. And they said, well, if we don't raise money from venture capital, we'll never go anywhere. And I said, well, humor me, let's do an S corp. And they did, and they were acquired 18 months later by a company, and they ended up saving, and they never took outside money other than friends and family. They ended up saving several $1 million just by that election. So that's sort of the default thing to keep in mind and have a discussion with your counsel when the time comes. Now, Section 83, this is one, if you've fallen asleep, wake up, because this is a big trap that can hurt you personally. So here it is. If you receive property in connection with providing services, property in this case would be stock in a company. You have ordinary income. That's just like the income you get if you're, working as a salaried employee, taxed up to 37% federally and add in the state. The amount of the ordinary income is the fair market value of the property you received minus what you paid. So let's have an example. Suppose I like your idea and I say, look, just to make the math easy, I'll give you $1 million for 50% of the company. Let's set it up. And you say, wow, we're off to the races. We're going to have this great startup. Well, if we set the company up and you receive stock, 50% of the stock, and I receive 50% of the stock, you could say that the fair market value of your 50% is $500,000 because you own half of the company and the company only has $1 million in assets, and you paid nothing. And so you have ordinary income maybe of $500,000, and if it's taxed to make math easy, 40%, you owe $200,000 in cash. On the other hand, you could say, well, wait a second, maybe it's even more, because if I paid $1 million for half the company, doesn't that mean the other half of the company is worth $1 million? And you do the math there, and you might own $400,000 in cash. Not a pretty sight. So how do we avoid the Section 83 trap, as it's called? Well, you want to try to separate in time when stock is issued to you from when the investment are made by others. So if you incorporate today, it's going to take you a while anyway to bring in investors. Incorporate now, issue stock now, and make what's called an 83B election, which says I want to take my income hit now, and there's no value today. So the question is, why does stock not get issued in time? Well, people procrastinate, right? They're too busy, and so they wait, and all of a sudden we get a term sheet from an investor, or we better go get a corporation, and now you're back in the trap. Or maybe you're not sure, you haven't quite figured out the deal among your founders, so you're not sure who gets what. So this particularly happens on procrastination around technical co-founder and a business co-founder. So if I have a graph that says, I have time on the x-axis, and I say, what's the relative importance of the technical person at the beginning of a venture? That's probably high here, because if we don't have something that's going to work, we don't have anything. And the business person, if we don't have anything, there's no business. What happens over time is the relative importance of the technical decreases and the relative importance of the business increases. But the dynamic is, at the beginning, the technical founder is saying, well, wait a second, it's my idea. I've worked hard. I'm going to be working, 80 hours a week, 100 hours a week, trying to, get the prototype working. And you, the business person, are still doing your day job. And yeah, you're working on the weekend, but you're getting money. And so I don't think I ought to really give out much stock, because I'm really important. And we never can quite reach an agreement. And we muddle along, and eventually, we either don't do a deal or we issue stock right before an investment. So thinking about this dynamic, this is a long discussion, but this graph, I think, encapsulates a typical problem that you see in co-founders that are technical and co-founders that are business. How are we doing on time? I think we only have a couple minutes. I do need to touch on this founders thing, and then I'll come back to questions. As said in the earlier part of today, sort out your relationships up front. Stockholders in a closely held corporation owe a duty to each other. You want to figure out who's on the board, who holds what titles, and you want to think about restrictions on stock transfers. What if somebody wants to sell their stock? Do the other people get a right to buy? A bunch of other things. How are you going to handle things? I think the best thing for you to do here is to read the founder's memo on the class website. This is a memo that I wrote after having, a long time ago, after having 3 startup teams from MIT show up at my desk office, and we went over the same things each time. And I said, this is really not productive. It's too much for them to digest in a short sitting. And, I'm either can't charge them for all this time. So I went home, I wrote the beginning of a founder's memo, and I said, before you even come in and have a discussion with me as a lawyer, or since I don't practice anymore, anybody you would have write something up for you, read the memo and try to sort out the things, at least know what the issues are before you go in. And that's the founder's memo. I'm going to, let's see. This is, we're going to cover some of this in Charlie Tillett's thing, so we'll talk about, I'll back up. How do you split up equity, both among founders, and what about what's the equity philosophy in a company? Well, it depends. So Keenan Systems is a famous MIT founded company. Keenan was a professor at Sloan, set up a telephone billing system, telecommunications billing type system. It was sold to, I think, AT&T for $1 billion. He owned 100% of the company. On the other hand, the people he employed were paid very well. So when you think of how do I split up equity, it doesn't have to be everybody gets it. On the other hand, there is a market out there for talent. And if people assume that they should get equity for some things, then you may have to figure out how to do that. And so that's a broader discussion that we'll talk with Charlie Tillett about. If you do decide to give out equity, the question is, what percentage of the company goes into an equity compensation pool for employees or advisors, etc.? And the typical initial pool is the amount you need to issue in 2 to 3 years of operations. And that's tied to the headcount plan when you develop out your financial projections. Charlie will go into more of this. The net effect of that is, for a typical first round venture financing, 12 to 18% of the company goes into the pool. And these are the people that could be eligible to it. And these are, Charlie will go over it again, this is typical ownership of the company after 2 rounds of financing. These are people who would come in, the CEO or the VP, etc. I mentioned at the beginning that we were probably going to run out of time, and it looks like it, so I'm going to stop the presentation now and see if I can answer some questions, if that makes sense. Do you want to, Krause,
Thanks, Joe.
or who's how should we do this?
I just want to announce that I'm dropping the attendance link in the chat, just in case anyone's hasn't filled it out yet. But other than that, we have a few questions. Please feel free to raise your hand.
Okay, let me say it, because I saw one of the questions. These slides are already on the nutsandbolts.mit.edu/session3 page, so you can pick them up there. So I'm happy to stay and answer questions, but I do mindful of the, we're close to 9 o'clock. So what do you have there for questions?
I've got any advice for international students? Oh, I've got another one before that. What if you have a solo founder that incorporated but haven't issued stocks?
What, relative to Section 83 or?
I'm not sure when it exactly came in.
Okay.
Amy, do you want to elaborate? Otherwise, we can move on to Gideon's question.
Yeah, it's related to Section 83.
Yeah, so the point is, this would happen to me all the time. You would come into my office back when I was practicing law, and you'd say, Joe, wait, you just got a term sheet from this venture capital firm. We're going to invest, I don't know, $5 million, $10 million, whatever it is. We need to set up the company. Well, the problem at that point is there's no company, there's no stock issued. And how does the value, if they're going to put that money in 2 weeks, what's the value? How do we determine the value today? Well, it's unless you've got a patent or something. And so really by separating those in time. So even just setting up the corporation and not issuing the stock is a problem. One of the things that's going to happen, and that we didn't get to tonight, is the concept of vesting. So if I'm going to put money, when I as an investor put money in the company, I've done everything basically that I said I would do. I mean, I'm there to help, of course, and I really want to help the company grow. But you as the founder haven't done anything yet. And so its typical terms are that your stock is going to vest, meaning that if you leave, some of that's going to come back, and so we can use it for other people. And when you have vesting, the 83 problem gets even worse, because the measurement of the value is when the stock vests. And that can just, if everything's going well, that can be a huge, hopefully a huge value increase. So there's a thing called an 83B election, and that says, I want to take my measurement today. Now the problem with that is you have to file the 83B election within 30 days of the date that you get the stock. So if you incorporated a year ago and never issued the stock, and now you're claiming that your stock was issued a year ago, and you're going to have it vested, it just doesn't work. So the trick is issue that stock. Even a single share issued will be 100% of the company if no other shares are issued. Does that make sense? So, but once that stock's issued and you're giving away the other part of the company, you've already got your stock, so it's not receiving it in connection with providing services. Does that make sense? Oh boy, there's a whole question about TLO. I'm going to have to, Stephanie, I'll have to cover that separately with you. Okay, any other?
There's a question from Gideon saying, any advice for international students on starting and incorporating a new venture?
Well, there's a whole immigration aspect to it. Yeah. The you certainly there's no prohibition about incorporating, and you can go ahead subject to any work visa type things. There's really no problem to doing that part of it. There's an issue with subchapter S. There's an issue of whether you can pay yourself something, and that gets into the whole area of immigration law, which is a whole other discussion. I can send some links on that later. I'm going to make a note of that. Any other? As I said, I was going to hit you. I was going to hit you with a lot of stuff tonight, so I know it's hard to digest all of this.
I have a question.
Yes. Mm-hmm.
Well, I plan to hire some contractors to do something for me.
Mm-hmm.
If how will I ensure that they will not take my idea or do their own stuff competing with me? So is there some sort of non-compete agreements or non-disclosure agreements that I have them sign before I can hire them?
Sure, you can do all that. The question is, if it's really sort of implementing an idea you have, and you've already filed a patent application, then you're going to have priority over them. But in addition to that, there are contractual ways of doing it, which would be non-compete agreements. Now, as it relates to employees, I should say that non-compete agreements in California are not enforceable. And there's been discussion in the U.S. that, except in the connection with selling a business. In other words, if I'm selling you a business and I move across the street and open up the same business, then that non-compete is enforceable. But in California, the typical non-compete things that you would see with employees just don't hold up. So there are a variety of contractual things you could do depending on the nature of what you want the contractors to do. An important thing is to make sure you own, if that's the deal, you own what you're paying for. And that would be as part of the consulting agreement that you'd sign up with them.
Okay, thank you.
Good. Okay, we're past 9 o'clock. I knew we weren't going to cover all of this. So anyway, take a look at the slides. I'm happy to take questions separately. Just again, to help you understand a little bit of it. This is not legal advice again, but I want you to understand where some of the pitfalls and the potholes and all of that stuff will be. If you are taking the course for credit, just to remind you that we encourage team formation. And I think, Raz, did you send something out about notifying? Having people
no, but we will send an email tomorrow with like all the information and also the Google Sheet that they can use in order to let us know its information. And we're also going to send in the same email all the information to join the WhatsApp group, the general one, and the subgroup for the specific areas so that they can communicate among themselves. We are planning to send them tomorrow morning.
Okay, and we'd like to know, I know it's very short. We used to stretch this course over the entire month, but because of where the Sloan people were traveling and not, we've compressed it to the back end of the month. And team formation is really important if we can do it. As I think I said at the beginning, if you're taking the course for credit, certainly a team effort is encouraged. I'm not looking for teams of 10, 3 or 4 would be fine. If you're having trouble finding a team, the TAs can help on that. I hope to do that. We'll handle those requirements on a case-by-case basis. And so with that, I guess we'll see you next Tuesday for session 4. And I'm always a little, I wouldn't say unhappy, but we get finished with the legal section, because we could certainly use a lot more time for me to get through all of this, and certainly looking at the questions you have. But we do as much as we can, and hopefully you've learned something from it. So with that, I think we'll call it an evening, and we'll see you on Tuesday.
Thank you so much, Joe.
All right, take care all.
Joe.
Fantastic session.
Okay.